Here we are. Spring is coming. The birds are breeding. What will we talk about today? Look, I was thinking of looking at a subject which I think you'll find dry and boring, but which is fundamental to Australian society. I think we'll talk about the Australian Constitution. The Australian Constitution has been described as a document which is devoid of explicit values, aspirations, and rights. And when you look at this document, what's called the founding document of the Australian nation, when it achieved independence from the British on the 1st of January 1901, you can see that it is devoid of values, aspirations, and rights. Considering this was the first time in human history that a national constitution had been decided by a referendum of the people, or multiple referendums of the people, it's interesting to note why this fundamental document is devoid of values, aspiration, and rights. Now, when you look at the history of the Australian Constitution, it is a federation of 6 colonies. These colonies evolved as British colonisation expanded across the Australian continent. And over a 12-year period, from 1889, where Henry Parkes, the Premier of New South Wales, gave the Tenterfield Address, which set the ball rolling for the unification of the 6 colonies. The fact is that this was a complex process which initially only involved leading lights and political figures and landowners in Australian society. But after the 1893 Cowra People's Convention, the momentum was created for the new constitution to be drafted by 10 electoral representatives from each state. What that meant is that every colony, using the electoral system they had in place, elected 10 delegates to constitutions of 3 major constitutions between 1897 and 1898, which drafted the Australian Constitution. There were 3 issues which united, which forced the colonies to talk about federation and unification. They were tariffs and duties. Believe it or not, each state had tariffs and duties regarding goods which crossed their borders into the other colonies. And New South Wales, being the largest state, it had the lion's share of tariffs and duties which were collected. At the same time, immigration had become a huge issue in this country. And what we saw was the creation of a white enclave in the southern hemisphere. And the third issue, which concerned the colonies was German and French colonisation of the Pacific, so defence. So the three major impetus were tariffs, immigration, defence. Now, you would think that giving the people of each state the ability to elect delegates to the Constitutional Conference, or a number of constitutional conferences, would democratise and include values and aspirations and rights for the individual within the Australian Constitution, but it didn't. There were two emerging groups at the end of the 19th century and the beginning of the 20th century. There was the women's suffragette movement, and in 1897 they were denied universal female suffrage in the Australian Constitution, the addition of universal female suffrage. And there was the Labor movement. And of the 60 delegates which were elected, only one represented the expanding Labor movement out of 60 delegates. Now, to make matters even more interesting, what we saw is that only 4 of the states which elected delegates, Queensland couldn't come to a decision till later on in the process because it wasn't able to pass legislation to enable the election of delegates to the Congress. West Australia, Parliament selected the delegates. So you can see that the composition of the delegation basically represented the major financial interests in the country at that particular point in time. Now, when the referendums were held, there were 2 series of referendums. There was one in 1897, I think, and one in 1898. Could have been 1899. And what we saw was a significant majority of people who voting for federation. Now, the problem was that the electoral laws that were in place were the electoral laws of the specific colonies. And in some colonies, people of colour, Aboriginals, Chinese, whatever, couldn't cast a vote unless they owned land. In other colonies, if you were in receipt of benefits from the state, you couldn't vote. And in all the colonies except West Australia and South Australia, which had women were not able to vote. And obviously voting wasn't compulsory. So only about 700,000 people were involved in about 800,000 people were involved in the voting, and the voting was about 65% for federation and 30 to 35% against federation. So you would think that a document which had been drafted by elected delegates would have had values, aspirations and rights incorporated into its framework. Well, it didn't. And although minorities at the Cowras at specific conferences, federation conferences, wanted the introduction of human rights in the Constitution, the overwhelming feeling was that this was a constitution which would be based on the removal of tariffs, restrictive immigration, and which would create a Commonwealth Defence Force to defend the continent against French and German interests in the area. And that is what we got. The Australian Federation is nothing more than a trade document which regulates the relationship between the states and the central government. And what we've seen over the last 125 years is more and more power shifting to the centre. But the important thing it is the relationship between the central government and state governments, because we are talking about a federation. That's why each state, irrespective of its population, for example, Tasmania has a population of less than 600,000 people, while New South Wales has a population over 7 million, each have 12 senators in the House of Review. So this is a document which regulates the relationship between the states in terms of their ability to interact with each other, their ability to trade. Ultimately, it has no explicit values, no explicit aspirations, and a handful of rights. And these rights are the right to a trial by jury for indictable offence, the right to just compensation if the Commonwealth seizes your property or land, the right not to be discriminated against depending on your state. So again, this harks back to federation, where it was important that if the country federated, that people were not discriminated against because of the state they were living in, and the right to freedom of religion. So although we hear people who should know better claim we have freedom of speech, freedom of association, freedom of assembly, the right to housing, the right to a subsistence level of existence, the right not to be exploited. The fact is, and the High Court has demonstrated over and over and over again, that enlisted in the Australian Constitution. These deficiencies have been highlighted over and over again. Of the major Western powers, the Australian people have fewer constitutional rights than any other Western power. In this country, what we consider to be common law rights can be removed by legislation as long as the governing party has a majority in both houses of Parliament. So we have seen in the last 40 years the passage of draconian legislation, which in the majority of cases has not been enacted, but over the last few years as resistance to the state increases among certain sections of the community, we have seen this legislation coming into force. Now, Australians would be horrified to know there is no constitutional right to strike. And successive Labor and Liberal National Party governments over the last 50 years have passed legislation which prevents people from withdrawing their labour outside an assigned enterprise bargaining agreement period. And if they do, they can be jailed, they can be fined individually $10,000 a day. So we talk about the right to strike. They don't have it in Russia or China or North Korea. Well, we don't have it in Australia. Then we talk about the freedom of assembly, freedom of speech. It wasn't until 1996 that the High Court of Australia found an implied right to freedom of expression only during an election period, because you couldn't have an election, a parliamentary election, without freedom of speech. Now, after the 9/11 tragedy, we saw a slew of legislation introduced in this country which highlighted that the individual and groups have no protection against the arbitrary exercise of state power in this country. We saw legislation put in place which allowed this country's police and secret services to detain people for up to 7 days without any charges being laid, because they may inadvertently have information that may assist them in the investigations. And they can be jailed incognito. What that means is basically you can be swept off the streets, held in prison, questioned for 7 days. If you refuse to answer questions, you can be jailed for up to 7 years. And after those 7 days, if nothing has been found to implicate you in anything, you're discharged. If you tell anybody what has happened, you can be jailed for up to 7 years. I'm not making this up. And this occurs because there are no constitutional protection. As far as groups are concerned, the government, the Minister for Home Affairs, formerly the Attorney General, can at any time ban any organisation because they believe or feel they may pose a threat to Commonwealth property or interests. And if people protest or raise money to defend these people who have been arrested, they can be jailed for up to 25 years. The current climate emergency has resulted in more militant action by a small percentage of the movement against climate change, the movement that is trying to prevent the climate change and the climate emergency. We've seen various state governments introduce draconian legislation to prevent people, to jail people for relatively minor offences. We've seen permit systems introduced across the country which regulate people's ability to protest. So I think it's important that people understand that we have a constitutional framework in this country that is bereft of explicit values, aspirations and rights. And any government at any time that has a majority in both houses of Parliament can pass legislation to strip you or any organisation you belong to of any fundamental rights you think you enjoy because of common law and legal precedents. There is no protection for the individual from the arbitrary exercise of state power, and that goes back to the reasons that the original Constitution was drafted. It was drafted for 3 main issues. 1, to try to remove tariffs and custom duties between the various colonies. 2, it was drafted to set up a Commonwealth Defence Force to protect the Australian colonies from encroaching German and French colonisation in the Pacific region. And 3, it was set up to enshrine a constitution which would allow the state to deny everybody, including this country's First Nations people who are not white, entry to the country. No wonder it is bereft of values, aspirations and rights.